is also absolutely absurd. So I wanted to set that, I wanted to point that out.
Can you explain
to say
why?
That these two, I think that the facts are very clear in the record in terms of the differences between the two cases and
To
how
the
they were
juries, it
handled
was very
and the
clear.
legal- and the legal basis for
Yeah,
it.
and in both cases,
Asking about the privilege and waiver. And it seems as though my colleagues on the other side believe that a privilege or a waiver is based upon a word-by-word basis, and the extent to which they may have waived any kind of a claim of privilege for the words that were included in the transcript, they would still be able to claim a privilege for the words that were left out, and that's what we're trying to get to with the audio, is also a legal absurdity. That is not the way that privilege or waiver either one work. What it is when you waive the subject matter, then you waive the subject matter. You have waived your ability to claim a privilege for those issues. You're not able to use privilege as both a sword and a shield and say, well, I'm going to release these 4 words, but I'm not going to release these 16 words. These 16 words are privileged, but these 4 words I will give to you, and there's a waiver. What a court would rule in that regard is, to the extent the 16 words relate to the 4 words, it's a waiver of the entire thing, because they're not going to allow you to use privilege as both a sword and a shield, which is what my colleagues on the other side seem to imply. I'd like to read 3 quotes from the Her report that put the issue that you have raised, Mr. Reschenthaler, front and center here about Mr. Biden's cognitive abilities and why the audio is so critically important. Quote, Mr. Biden's memory was significantly limited both during his recorded interviews with the ghostwriter in 2017 and in his interview with our office in 2023. That's on page 5, I believe. Quote, we have also considered that at trial, Mr. Biden would likely present himself to a jury, as he did during our interview with him, as a sympathetic, well-meaning elderly man with a poor memory. That is on page 6. Similar quote on page 219 of the report. And finally, Mr. Biden's memory also appeared to have significant limitations, both at the time he spoke to Zwanitzer in 2017, as evidenced by their recorded conversations, and today as evidenced by his recorded interview with our office. That's at page 207. I'd like to bring this back to actually what the purpose of this hearing is, which is our oversight responsibilities, both as the Judiciary Committee as well as the Oversight Committee. That's what this is all about. And I would say it's very obvious that the point of the other side is to deflect attention. They want to deflect attention from the fact that Joe Biden had unlawfully kept classified materials and shared them with his ghostwriter, for example. They want to deflect attention from the fact that clearly the audio and the written transcript are different, and that those differences might be incredibly significant in terms of our oversight responsibilities. It's clear under the Constitution, it's clear under the case law that judiciary and oversight have the authority to obtain information such as this in carrying out our responsibilities as the legislative branch. That is really the only issue that is before this committee today. All this other nonsense, all this other noise, all these other words that are being thrown against the wall are entirely irrelevant as to whether we're entitled to this information, and if so, by withholding it, should Merrick Garland be held in contempt of Congress? And the fact is that he should, because there is no executive privilege. Even regardless of the transcript, there is no executive privilege for the information we're seeking, number one. And number two, if there was, it has been waived, and we're entitled to receive the information, the audio that we have requested. With that, I yield back.
Thanks, Ms. Hageman. Mr. Nadler?
I want to point out that the Her report, contrary to the insinuations of the gentlelady from Wyoming, repeatedly states that he did not indict Biden because the evidence of a crime just did not exist. Some sample quotes on page 4 of the Her report, quote, we do not believe evidence is sufficient to indict, unquote. Page 6, there are, quote, innocent explanations, unquote, as to why Biden retained classified documents. Page 8, we do not, however, believe this evidence would meet the government's burden at trial, close quote. As I said before, that is why the special prosecutor declined to indict President Biden, as he states here, and that is why any reference to the president's alleged cognitive ability is gratuitous, because there's really nothing to do with this. I would like, however, to, the gentlelady from Wyoming a moment ago said that there were clear differences between the way the Hunter Biden trial was conducted and the legitimacy of that trial and the illegitimacy of the Donald Trump trial in New York. Maybe she'd enlighten us as to the difference?
I'd
Hageman.
be happy to, but I do not understand why that would be at all relevant to the
Because you brought
discussion
it up.
that we're having today. But I'm happy to have that debate
Please.
with you any day of the week.
Please.
But I just don't think that that's relevant to what we're discussing.
brought it up, so
I mean,
why
we
don't
can,
you
we
explain
can
it?
start with.
You
the
said it was
judge. The
absurd.
judge
Wait, hold
made-
on, hold on, Ms. It's
All
Ms.
right,
Hageman.
we can start with the judge that was handpicked rather than randomly chosen, which is typical in most of your court cases. You can talk about the fact that you talked about unanimity of verdict. We don't even know what the verdict was at this point in terms of what he was allegedly convicted of unanimously. We can talk about the fact that almost every single ruling that was made by by Judge Merchan in New York was against the defense, despite the fact that when you're dealing with a criminal case, there's either typically much more of a balance or in fact to ensure that the prosecution actually meets its burden of proving beyond a reasonable doubt, most of the rulings would be in favor of the criminal defendant, not in favor of the prosecution. It's in the fact that the expert witness, who is the federal election, former head of the Federal Election Commission, was excluded from testifying as an expert witness in the case in New York, despite the fact that he has been qualified as an expert witness to testify on these matters throughout the entire United States. It is the fact that there were other witnesses that were excluded. There was substantial evidence, prejudicial evidence that was admitted during the course of the trial. And then when you look at what happened with Hunter Biden, the prosecution was very precise, very specific about the nature of the statute that was at issue and how he violated it. And then they brought in the evidence from the family members, the ex-wife, the girlfriend, the Beau's widow, the young girlfriend, all of the testimony, him reading the book, all of the testimony. The evidence was overwhelming that Hunter Biden had violated the specific statute at issue. So there's dramatic differences in terms of how the New York case was handled versus how the case against Hunter Biden was handled. If you'd like to spend another 3 or 4 hours, we can go outside and I can give you additional evidence to that effect.